The timestamp on the internal memo reads 1:47 a.m. By 2:15, 12 senior congressional staffers had forwarded it to their bosses with a single line of their own added at the top. You need to see this right now. By 3 a.m., the lights were on in offices that are normally dark until sunrise, not just in Washington, in state capitals across the country, in the headquarters of political organizations that spend millions of dollars every election cycle trying to control the outcome of American elections, in the war rooms of campaigns that have been planning their strategies for months, because the memo contained 3 sentences that changed everything. The Supreme Court has acted. The ruling is live. And nothing about tomorrow looks the way it did yesterday. In over 200 years of American constitutional history, the Supreme Court has issued emergency election rulings a handful of times. Each one is remembered. Each one marks a before and after in American political and legal history. Each one forced the country to confront something about itself, about its institutions, about the gap between what the Constitution says and what powerful people have been doing in the Constitution's name. Tonight joins that list. And if you think this does not affect you personally, if you think this is something that happens to politicians and lawyers and election officials, but not to ordinary Americans who just want their vote to count and their government to function the way it is supposed to, stay with us. Because by the time we are done, you are going to understand exactly why what happened tonight in Washington touches every single person in this country, and why the panic that is spreading through the halls of power right now is not about politics. It is about something much more important than politics. It is about who actually controls American elections. And the answer the Supreme Court just gave is one that a lot of very powerful people were hoping they would never have to hear. Let us start with the panic, because it is real and it is specific. And understanding what people are panicking about tells you more than any legal summary can. The panic is not coming from one side. That is the first thing you need to understand. This is not Republicans panicking while Democrats celebrate, or Democrats panicking while Republicans cheer. The panic is bipartisan. It is institutional. It is coming from people in both parties, in election offices run by both parties, in legal organizations that have spent years on both sides of election law battles. Because what the Supreme Court did tonight does not pick a winner in the partisan sense. What it does is something more destabilizing than that. It changes the rules about who gets to pick winners. It changes the framework within which every future election dispute will be argued, every future election procedure will be evaluated, and every future challenge to how votes are cast and counted will be decided. When you change the framework, everybody has to recalibrate. Everybody has to go back to the drawing board. Everybody has to look at the strategies and procedures and legal arguments they have been building for years and ask the same frightening question. Does any of this still work? That question is being asked in Washington right now, tonight, in real time. And the people asking it are not junior staffers or political commentators. They are the people who run the machinery of American elections, and they do not have a good answer yet. Here is what happened and why it is so significant. The case that produced tonight's emergency ruling has been moving through the federal court system for the better part of a year. It began as a targeted legal challenge in a single federal district, a challenge that raised a specific question about whether certain election procedures in a key state were authorized by the proper constitutional authority. The question seemed narrow when it was first filed, technical, the kind of thing that generates law review articles but rarely breaks through to public attention. But the question was not narrow. It never was. The attorneys who filed it knew exactly what they were doing. They were pulling on a thread that, if pulled far enough, would unravel something much larger than a single state's election procedures. That thread is the Elections Clause of the United States Constitution, Article 1, Section 4, the provision that gives state legislatures specific constitutional authority over the time, place, and manner of federal elections. 4 words that have been at the center of more legal battles over the last several election cycles than almost any other phrase in the Constitution. The question those 4 words raise is deceptively simple. When the Constitution says state legislatures have authority over federal election rules, does it mean what it says? Does it mean that the legislature, the body of elected representatives accountable to voters through elections, must be the entity that makes election rules? Or can that authority be exercised by other actors, by governors issuing executive orders, by election administrators making regulatory decisions, by state courts issuing rulings that effectively rewrite election procedures, by a combination of all of these, operating outside the normal legislative process, changing how elections work in ways that no legislature ever voted on? The lower courts that examined this question gave different answers. The circuit split that developed was not a minor technical disagreement between judges with slightly different legal philosophies. It was a fundamental divergence about the meaning of constitutional authority in American elections, about whether the rules governing how you vote must be made by people you can vote out of office, or whether those rules can be made and changed and modified by actors who are several steps removed from democratic accountability. The Supreme Court took the case, and tonight the Supreme Court answered the question. The answer is this: constitutional authority means constitutional authority. The Elections Clause does not give state legislatures authority over federal election rules as a suggestion or a default that other actors can override when they have good reasons. It gives them that authority as a constitutional requirement. The legislature must act. The legislature must authorize. And when election rules are made or changed through processes that bypass the legislature, those rules lack the constitutional grounding the Elections Clause requires. That holding is significant in its own right. But what turned it into a bombshell, what turned it from an important legal ruling into a Washington-shaking emergency, is what the court said next. The court did not simply establish the principle and leave its application to future cases. It looked at the current state of election administration across the country and found that the principle was being violated, actively, right now, in states where elections are currently being administered, and it issued its emergency ruling with immediate effect. Immediate effect, tonight, with an active election cycle underway in multiple states. That is what the 1:47 a.m. memo was about. That is why the lights came on in offices that should be dark. Because immediate effect means tomorrow morning is different from yesterday morning for election officials in states the court has identified as operating under procedures that lack proper legislative authorization. Let us be specific about what that means on the ground. Because the panic makes more sense when you understand exactly what election officials are being asked to confront. In states where voting procedures were modified through executive action, through court orders, or through administrative decisions that were never voted on by the state legislature, those modifications are now constitutionally suspect under the standard the Supreme Court has just applied with emergency force. Not suspect in a theoretical future tense, suspect right now, tonight, with elections happening and ballots being processed and results being tabulated. The officials running those elections have to make immediate decisions about how to proceed. Do they continue operating under procedures that a Supreme Court emergency ruling has just called into constitutional question? Do they attempt to revert to procedures that were properly legislatively authorized, knowing that reverting in mid-cycle creates its own chaos? Do they seek emergency guidance from courts, knowing that courts are themselves scrambling to understand the implications of the ruling? There is no clean answer. There is no option that avoids disruption. The disruption is already here. The only question is how to manage it. And managing a constitutional crisis in election administration, in the middle of an active election cycle, with hours rather than days to make decisions, is exactly as hard as it sounds. The attorneys filing emergency motions tonight in federal courthouses across the country understand this. They are not filing those motions to be obstructionist. They are filing them because their clients, whether voters, candidates, or election integrity organizations, need courts to provide immediate guidance about what the Supreme Court's ruling means for specific procedures in specific states, and they need that guidance before more votes are cast under procedures that may not pass constitutional muster. Those filings are already in. Judges are being woken up. Emergency hearings are being scheduled for hours from now. The legal system is operating at a speed it rarely reaches because the situation demands it. Now, let us talk about the justices themselves, because how this ruling was written and who supported it contains information that matters for understanding what comes next. The majority opinion is notable for several things. First, its tone. This is not a tentative ruling hedged with qualifications and limitations. This is a confident, direct statement of constitutional principle delivered with the urgency the emergency designation implies. The majority is not apologetic about the disruption this ruling causes. It is explicit that allowing constitutionally unauthorized procedures to continue would itself be a form of harm that the court is not willing to sanction. The message is clear. Constitutional requirements do not yield to administrative convenience. Second, the majority opinion goes out of its way to address the partisan implications charged directly. It acknowledges that any ruling about election procedures will be read through a political lens. It rejects that lens explicitly. It states in direct language that the Elections Clause applies equally regardless of which party benefits from its enforcement. That the constitutional requirement of legislative authority over election rules is not a weapon for one side. It is a structural protection for all sides, because the value of having election rules made through accountable democratic processes is a value that belongs to everyone who participates in those processes. Third, the majority signals clearly that this is not the end of the court's engagement with these questions. It flags several related issues. Questions about the scope of legislative delegation to election administrators, questions about the role of state courts in election rule disputes, questions about the constitutional requirements for election certification procedures, as areas where the legal framework it has established will have further application. This ruling is explicitly framed as a foundation. More is coming. The dissent is written with equal force and deserves serious engagement. The dissenting justices do not disagree with the underlying constitutional principle the majority establishes. They disagree with the decision to apply it through emergency action in the middle of an active election cycle. The dissent argues that the harm the majority is trying to prevent, elections conducted under constitutionally suspect procedures, is a harm that could be addressed after the current cycle without the destabilizing effects of mid-cycle emergency intervention. That is a serious argument. It is an argument about institutional prudence and about the court's responsibility to consider the systemic effects of its timing. The dissenting justices are not wrong that emergency election rulings create real disruption for real voters and real election officials. They are raising a legitimate concern about the cost of acting now versus acting later. The majority decided that cost was worth paying. That determination is the law tonight. For voters trying to understand what this means for them personally, here is what matters most. The constitutional principle at the center of this ruling is one that actually protects you regardless of your politics. The requirement that election rules be made by your elected legislators rather than by administrators or courts acting on their own authority is a requirement that your participation in the election process be governed by rules that you, through your vote, have some democratic accountability over. You cannot vote out an election administrator who changes procedures you disagree with. You cannot hold a court accountable at the ballot box for issuing an order that modifies how your ballot is processed. But you can vote out legislators who make election rules you believe are wrong. That accountability is the constitutional logic behind the Elections Clause, and it is a logic that serves voters on both sides of every political divide. The panic in Washington tonight is real. The disruption is real. The emergency legal proceedings are real. All of that is genuinely happening, and none of it should be minimized. But underneath all of it is something that is not chaotic, something that is not panicked, something that is steady and principled, and has been part of the American constitutional design since the beginning. The idea that the rules for American elections should be made by people who answer to American voters, not by administrators, not by courts acting beyond their proper role. not by executives issuing orders that rewrite election law without legislative authorization, by legislators, accountable, elected, answerable to the people whose votes they are setting the rules for. The Supreme Court said that tonight, clearly, urgently, with immediate effect. The memo that went out at 1:47 a.m. is already history. The phone calls made between 2 and 3 a.m. are already history. The emergency filings going into federal courthouses as you watch this are going to be history. What they are all responding to is a Supreme Court that looked at how American elections have been administered and decided that the Constitution it is sworn to uphold required it to act. Now, tonight, without waiting for a more convenient moment. That is the bombshell that dropped in Washington tonight. That is what the panic is about. And that is what every American who believes their vote should be governed by rules made through a process they can actually influence needs to understand before another day passes. The lights are still on in Washington. The filings are still going in. The emergency hearings are still being scheduled. And somewhere in a building that has seen more American history than any other, 9 justices who just changed something important are going about their work. The timestamp on history tonight reads 1:47 a.m. Remember it.